What's up? All right, so I have no idea what's going on. The layout of StreamYard is so different. They did some stuff. I don't know what they did. Let me see if I'm able to share the. I don't know. This is so weird. They changed some stuff up. In any event, I see old bags here. I don't know. Hopefully, she brought her jump rope and all the good stuff. I'm kind of conflicted. Okay. I'm conflicted because what's up, Brooklyn? I'm conflicted because a part of me wants to continue from yesterday's hearing, but I don't know. I also kind of want to jump into today's hearing. So I don't know. Let's just carry on. That's old bag said, "Give it to us." I don't know. Getting distracted. Getting distracted. Stay on track. All right, let us carry on from yesterday's. I don't know. Part of me actually want to get into today because at least I don't know. Law and crime. These folks are misleading sometimes though, because it appeared that Jackson and Bev were going at it, but again, that might not even be accurate. So I'm just gonna carry on from yesterday. Okay, old bag wants to get to today. All right. Old bag's the boss, so that's who we listen to. All right, let me just take down this timestamp. One moment. I cannot open any more tabs. I have like a million tabs open. Okay, so that's where I left off. Let us get into today. Yeah, this is what I saw. I guess it's Core TV. I said Law and Crime. This is what I saw, but I'm like, what if it's not promising? Let's get into it though. Let's get into it. Let's see.
End quote.
What are they?
That sentence says a lot. It said a lot to me.
It does not.
That Lieutenant.
Okay, let me actually find the actual video.
Are in charge of the jury.
Your Honor, I'm getting to that.
And they started fighting.
That.
They started fighting from the very beginning. And why are these people late? These law and crime folks. Anyways, let's get.
But if you'll allow me to make the argument and to indicate what as my declaration says, my good faith belief, based on reasonable belief, this is how we get there. We were then asked, or the court asked the court officer to join us at sidebar. He then indicated that it was Lieutenant Fanning. Ms. McLaughlin then went on to say, and by the way, he indicated that Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time, as the court knows. There was no declaration. There was no report. There was no supporting documentation whatsoever, no recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror where she said, not that I remember, no. That was the initial statement that she said in terms of any misconduct. No, I wasn't talking about the case. Over the defense's objection, this very potentially defense-friendly juror was excused. During that discussion at sidebar,
Brooklyn always has the facts, baby. Thank you.
That's when Ms. McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that—
Old bag, is that for Brooklyn? There's no way. I'm no leader of no pack. that must be Brooklyn. That must be Brooklyn.
This case has required. Period. End quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that
and
he has—
I'm just going to stop you. I'll let you finish in a minute.
Okay.
Mr. Yannetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge.
Oh, wow. Okay. So I guess this is the distinction between, local counsel and folks that aren't actually admitted in the state.
Of the jurors. Go ahead, Mr.
Don't practice
if there is a commander
all the time
of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up,
Okay.
Ms. McLaughlin told us. We were told he was the commander, not part of a security operation that was outside the court, not part of a security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't. Again,
You were told that at sidebar
No.
that day by Ms. McLaughlin.
No, we were not. We were
I
told.
have the transcript.
Well, Your Honor, what we were told is what his title was. Commander of the extensive security operations of the court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors.
Obag said he was not impressed by Hank, and why is that?
But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time in good faith. Both Mr. Yannetti and I asked the court to take evidence from Lieutenant Fanning. The
I think
court
it was Ms.
declined.
Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue, so I wouldn't have to make reasonable conclusions. I would actually have the information. So of course, that's one of the issues that is attendant to our motion to dismiss, because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors.
Okay.
He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather
What
Maxson.
lies?
He interviewed all of those individuals.
I did not get to
or
watch
took
this.
part in those interviews. Lieutenant Fanning was at the defendant's.
I did not watch today's hearing. My day was very chaotic, you guys. I'm surprised I'm even here. I'm surprised I'm here, not losing my mind. I had a very stressful day. Stressful day.
And seized her cell phone in January of 2024.
What's up,
just
Jerome?
months before the trial began. Lieutenant Fanning was included on the text
All
chain
right.
where Trooper Proctor said he was going through my client's phone looking for nudes.
Obag's excited for some reason.
And then his name comes up at sidebar as the commander of the extensive security operations attendant to this case. And he's the source report to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court. It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly why we put it in our papers. And without additional information clarifying that, we have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago when you already knew that he did not
What's up,
have
Angie?
any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and
Obag, my day was stressful because I have a real job. I mean, I guess you could technically be unemployed and still have a stressful day. It was a lot of deadlines. Yeah.
penalties of perjury this 21st day of February 2025.
Correct.
What's up, Benji?
We were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors is when we received our responsive documents from the opposition
notes.
from the Commonwealth. In that document, they mentioned he never had any direct access. He didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed the opposition. That's the first time someone.
Supporting evidence is why a stressful day, Obag. So why I had a stressful day? Because I was filing oppositions, I was putting out fires. Uh, I'm impressed with myself though, because I actually got an opposition out in an hour and 30 minutes, which is kind of record because usually it takes me much longer. But I kind of took shortcuts, which is not good because I actually prefer going through all the records. In any event, it's done. But yeah, uh, that's why I had a stressful day.
Someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court.
All right. Well, Jerome, I don't know. Old Bag suggested that we actually watch the first trial. I don't know, Brooklyn. How do you feel about that? Old Bag thinks we should watch the first trial in order to bring Benji and Jerome up to speed. Callie actually watched this trial. We watched it together, but I was not active on YouTube then, but we talked about it a little bit.
Is the information we were working from.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson.
I
Put it
hate.
this way. Let's say
I know I'm complaining. I should have my own live streaming services, but I hate that they started streaming in the middle of the actual hearing because I'm trying to figure out what Bev Canoni is upset about. I don't know. I guess she's not a fan. Let's go back.
Information we were working from.
Yes, she's not a fan. But she said she's not satisfied.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson. Well, put it this way. Let's say it this way. So now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized? Now that you know it's not true.
Why were you putting out fires on your wedding night, Old Bag?
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors? I don't know that to be true. I mean, I take the court at its word, obviously, clearly.
So we will move on from that, Mr. Jackson. We'll move on from that. So
well, the court's asking what is our evidence of, or what's our indication of the impropriety of him being the person that actually reported this misconduct and ultimately leading to the exclusion of a very, very defense-friendly juror, or presumably.
Okay, I see what they're saying.
A defense-friendly juror, and knowing at the same time that he was intimately involved in the prosecution of my client. That's the reason, because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case, and he ends up, just ironically, who knew, he ends up being the source of the information that got that juror removed. That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that shouldn't have happened. He certainly never, ever should have had any access, even in the orbit of the jurors, directly or indirectly. And the court never even inquired as to why he was the one receiving the report. Why Lieutenant Fanning, of all people, who then reports it to the court officer, who then reports it to the court, who then removes the juror.
Let's do this. We're going to borrow from NBC Boston, okay? So this is a recap. I don't know that I like the why am I complaining? I should have gone out there and done it myself if I had better things to do. Anyway, so if I could do a better job. So this is the recap from today's hearing, okay? We're just going to recap and then we can listen to the audio because I get a sense of what I think I understand what Jackson's arguing about, but let's get to the bottom of this, okay? So this article is titled "Recap: Karen Read Has Major Hearings in Federal Courts." Okay, they say it was another busy day in the high-profile murder case. I don't know what they're talking about here. Hold on. Okay, so Karen Read had big hearings in both federal and state court Wednesday, less than a month before her retrial over the killing of John O'Keefe. Here's what happened in both hearings, plus analysis from Michael and Sue. I guess these are interviews or whatever. And the second part of our interview with a juror from, maybe we go here. Okay, this is an article, but I guess we find NBC Boston because they have an interview with a juror. In any event, in the second part of our interview with a juror from the first trial who shares advice on what the side should do in the retrial. Okay, that's not what we're concerned with. Never mind. Okay, what to know. Karen Read is back in court Wednesday for 2 hearings. One in federal court. They already said that. Anyways, Read's second trial is expected to begin on April 1 after a mistrial was declared last summer when jurors were unable to reach a unanimous verdict. Reed is accused of killing her boyfriend, Boston police officer John O'Keefe, by hitting him with her SUV outside her home in Canton in January of 2022. Wednesday was a busy day. You guys already said that. Okay, they keep reiterating how busy it was. So the first hearing in federal court was held in the morning, followed by one in Norfolk Superior Court just afternoon. Reed is accused of killing. They said that already. Okay. She has pleaded not guilty and alleges she was framed. Okay. At her first trial, jurors were unable to reach a unanimous decision, leading to a mistrial. Didn't you guys already say this? Follow along with what happened from both hearings below. Okay. So I guess I have to scroll to the very bottom because they have a timeline. So 13 hours ago, they said back-to-back hearings on Wednesday in Karen Read's case. Karen Read's defense seeks dismissal from court Wednesday. That was 13 hours ago. Karen Read arrives in federal court. Federal court hearing underway. Defense prosecution argue their case. Federal court hearing over. Judge takes matter under advisement. And then 9 hours ago, because we're interested. No, we don't want photos of her. Hold on. Okay, so we're going to 9 hours ago. Can I click on this? Okay, so defense starts argument over motion to dismiss. That's 8 hours ago. All right, and then 8 hours ago, apparently Cannoni tells Jackson, I'm not really satisfied with your answer. We just heard that. Next up is in defense argument to dismiss Canton police evidence. Want to know more about Karen's motion to dismiss. Read it here. Okay, that's where we're gonna go. Defense, missing videos. All right. I'm sorry, folks. I'm parenting. As you can hear, I'm parenting. Okay, so let's go back. Okay, they keep talking about her killing or accused of killing the boyfriend. Like, how many times are you gonna say that? All right, so she listed deadlines. We're not interested. Okay. I don't know. We're gonna have to watch that. We're actually gonna have to watch. We're gonna actually have to watch the hearings because these people are not talking about anything. Okay, part of the defense motion to dismiss the case against Reed involves a claim that a member of the investigative team oversaw security in court at the trial, but Brennan portrayed that as a deliberate attempt to use a rumor to poison proceedings. Jury tampering would be one of the biggest, most abhorrent transgressions that could happen, he said, and likewise a baseless claim of tampering. Yeah, I don't like reading articles. Let's just watch the whole thing. Let's go.
It's an awfully straight line between Lieutenant Fanning.
I mean, it's okay if your wedding was on fire, Oldback. We just need to know the details
Who has an interest in this case and the removal of a juror.
We are
That's
nosy.
improper in our view. And that's why we put it in the papers, and that's why we argued it the way we did. Because we were working off of
Brooklyn
Brooklyn
raises a good point. There's no need to go back.
At sidebar in the court's presence.
Okay.
All right, so that's your answer to my question.
That's my answer.
May I have a moment to confer with counsel?
Yes.
Jerome's so funny. My question is, I'm gonna have to get my glasses. But if I get my glasses and I don't put them back, we are gonna have real problems. Then my day will definitely be far more stressful.
Thank you for that. The court invoked Mr. Unetti and said, as local counsel, he knows this not to be true. Mr. Unetti just indicated to me that that's not quite the fact. And so Mr. Unetti, I think, should be able to at least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Unetti. So if the court would allow Mr. Unetti to explain what his experience is, that may elucidate on this issue.
If we have time later, go on with your argument.
Baby, something else. And that's why I keep saying that A$AP Rocky definitely got lucky with the judge, because sheesh, I don't know if Bev is impatient, if she has, I don't know. She's actually, let me look up.
I'm happy to, Your Honor, and thank you for giving me the opportunity.
Let's look up.
The cumulative discovery misconduct by the Commonwealth, as laid out in our moving papers through their agents, has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers. But I want to concentrate my argument for the court this afternoon on the exculpatory Sally.
She has been on the bench for quite some time, okay? So she was nominated by the former governor in 2014. And then her nomination was confirmed the same year. And dang, she may serve on the court until she turns 70. That's crazy that hopefully she's not on the bench for that long, because if you're, I don't know. Anyways, you guys know that I'm always talking about retirement, things that have nothing to do with
videos.
What's here? Okay, in any event, it appears that she has been licensed for at least close to 40 years, okay? She received a BA in 1982, and then she earned the JD in 1985. And if she took the bar immediately after she got her JD, that would mean that, right, that again, this is 1985, so I don't know how they were doing things back then, but it means that she would have been licensed either the same year she passed on the first try, or the year after, or maybe I don't know how many times she took the bar. But yeah, she does have extensive experience, at least on the bench. And then prior to being a judge, she was a staff attorney for the Public Counsel Services. That's actually crazy. And she was on the murder team for 19 years. I know that sounds crazy, but she was apparently on the CPCS murder team for 19 years. And then she was also the attorney in charge. I guess she led that department that section, that division, for 3 years.
I'm waiving any of our.
That's different though, because I expected, that's the problem with assumptions. I was expecting to see a resume that is more in line with, I don't know, I maybe thought that she would have been a prosecutor, but that doesn't appear to be the case. So she worked pretty much she was a public defender. Shout out to all public defenders, okay? Shout out to all public defenders. But yeah, she was sounds like she was a public defender.
Our arguments in the moving papers, but in the interest of time and focus, I think it bears upon the court at this point to consider most prominently the Sally Port issue.
All right.
Or the Sally Port video issue. The Commonwealth, to start off with, two facts that are true.
Hold that. I do not necessarily, and I understand, but I do not necessarily, you guys already probably know what I'm going to say. I do not necessarily think that the activity by the police officers was suspicious, but the investigation was not as thorough. And the reason why that is, from my perspective, at least from my experience, is because this was a small town. It's a small town where everybody knows everybody. Usually in small towns and in smaller counties where folks know each other, and it's, the old boys club and folks that pretty much interact with each other on an everyday basis. Somebody's cousin married somebody and the kids played hockey together, the like. typically because of the nature of their relationships, um, law enforcement tends not to do a thorough job or a thorough investigation. And that's typically how it is in smaller towns. So to me, I believe that is the largest or the biggest reason why investigation was not thorough. And I don't think it's limited to the Karen Reed case. I think that generally that is how they'll typically investigate cases over there because everybody knows everybody. Uh, in comparison to a larger city, though, where people just don't know each other, people don't have relations to the extent that these folks do. Investigations tend to be a bit more complete, not just a bit more complete, but a bit more formalized.
The Commonwealth cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not deny that untimely disclosure. And they also
That's
cannot
funny.
deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. So what do they do in their opposition? Most of the time they spend saying that the prosecutors themselves
Dang, Oldbag and Brooklyn are actually filling in the information for Benji and Jerome. I love it.
did not know. They had no actual knowledge. Well, they concede the unavoidable in their moving papers, which is that the Massachusetts State Police and the Canton Police Department both knew about the evidence and both withheld it. Conveniently, they throw much of this on the back of Michael Proctor. It was sort of to be expected. He's already damaged goods, so why not? And they also bring in a newly
damaged
revealed
goods.
sergeant.
Shout out to
sergeant by
Big
the
Sue,
name of
though.
DG Petro, who's already retired, gone from the police force, and who interestingly retired.
They definitely do not know anything about investigating out there. They don't. I don't know. Yeah, they're very problematic.
Just 2 days after the Commonwealth's October 2024 disclosure revealing previously withheld Sally Port video.
I'm just going to ask, is he available, Mr. Brennan?
Not today, but he could be available.
I'm just curious. So he's still around.
He is,
Okay.
yes, and it's cooperative.
All right. All right, Mr. Jackson, go ahead.
Our motion illustrates that, and by the way, I'll walk through the videos that we did get and when we received them. Our motion illustrates that dismissal in this case is required because of the cumulative impact of clear-cut discovery violations.
All right, and then I don't know what's his name again, Jackson. So no, let's move on. I was gonna talk. I was just gonna go off. Let's keep going.
Inexcusable.
I was gonna go off on a random tangent. Let's.
Violations, and from a legal standpoint, the conduct in this case is so egregious, it's so pervasive, and it's so deliberate that prejudice must be presumed. We don't have to.
Yeah, and this might be a bit of a generalization, but typically and again, over and over again, folks have asked me about, plea deals. I believe even in the ASAP Rocky trial, I don't know, Benji, correct me if I'm wrong, but I think Benji asked me if I thought that ASAP Rocky should have accepted the plea offer, right? And again, you guys know how I feel about plea deals. I don't like plea deals. But here's the other thing as well. And when I keep talking about the distinction between factual truth and substantive truth, typically in jurisdictions where investigations are not properly done, oftentimes going to trial going to trial usually leads a higher acquittal rate. Okay, but that's again in counties where they just don't properly investigate, right? Where everybody's kids go to school together and the like. Usually in those jurisdictions, this is not legal advice, but from my experience, when I worked in counties where folks just did not investigate properly, an acquittal was far easier in those jurisdictions than, say, a larger city such as Boston, like the city of Boston, not these not the towns and villages and these little towns on the outskirts. And under those circumstances, even though personally I do have a problem with plea dealing, because again, I don't know about, I just don't agree with individuals ending up with criminal convictions when the prosecution has not proved its case beyond a reasonable doubt. But there are certain circumstances where it absolutely makes sense to enter a guilty plea, not even just enter a guilty plea, but to plea bargain and have a client or defendant plead out to a lesser charge. But again, it just depends on what the evidence shows.
Prove prejudice, it should be presumed. To begin, I want to start the issue by talking about the condition.
What do you mean by that,
of
Jerome?
Ms. Reed's,
Oh, great, Britain, got it.
Ms. Reed's passenger taillight. The condition of that SUV passenger taillight at the time it was brought into the Sally Port at Kenton PD is of critical importance. And that may be one of the most important facts in this entire
Brooklyn, I don't know none of these people. Like,
case.
I only know Alan Jackson from this trial.
It's important because we know as a fact now that not a single piece of taillight was ever recovered at
Hey,
34th
Brooklyn
Interview
for the
until
win.
after that vehicle was in the possession of Michael Proctor and the Massachusetts State Police. That is the foundation on which this entire argument is built. And it is an undisputed fact, although it wasn't undisputed for years. Other material facts that are not in dispute. The Sally Port video has been in the possession and custody and control of the Commonwealth since January 29th, 2022. That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. On April 4th, and I want to walk through what videos we did get and when. On April 4th, we got two videos. One was the Sally Port interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the Sally Port. And we
Okay,
also
so I
received,
just had to look up that case. That is different, though, in terms of, um, I guess it's the positioning, right? Because when I read Brooklyn's text, it basically says that, okay, I guess I read it incorrectly. Never mind. Because when I read it, I was of the assumption that Alan Jackson was the defense in that case. So maybe I just focused on Alan Jackson won the case. Prosecution usually wins. Yeah, the prosecution usually wins.
a Kenton Police Department.
Not even wins. That's not a good way of putting it. Now I'm speaking like a lay person. But the prosecution, usually when cases go to trial, again, it depends on jurisdiction and a whole, there are a lot of factors that go into it. But typically, the prosecutor is able to secure a conviction.
Driveway video with the SUV on the flatbed, which did not show the rear end of the car. On April 23rd, 2024, and by the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd.
Okay, so I was going to say Olbag, not Olbag. Jerome. So currently, the defense is arguing that the entire case should be dismissed, okay? And they're pretty much going over reasons why it should be dismissed. Maybe I should just pull up the that you guys know I'm so chaotic. I'm trying to figure out the proper format for this channel. Outside of trials, I'm really trying to figure out the proper format. But what the defense is arguing right now, they're trying to argue over the handling of the evidence and why the charges against Karen Reed should be dismissed. When we first tuned in, I did not watch this, but when we first tuned in, the defense was pretty much arguing that one of the prosecutor's witnesses or investigators was in charge of the jurors, okay, the selected jurors. And basically they're saying that because this individual is, works for, not necessarily works for the prosecutor, but is a prosecutor witness or investigator investigating this case, he should not have been in charge of the jurors. That's the argument. And then this second point that they're moving on to, they're pretty much arguing about the evidence as it relates to, if I remember correctly, I believe he mentioned the Sally Port. And the Sally Port, for anybody that doesn't know, that is, I guess, it's a structure, okay? There are a lot of, not all courts are this way. Not all courts are made up this way. Let me go back. Let me think. Every court that I've ever been into, just one moment. Only a few courts have the ones that I've been into, the ones that I'm practicing, only a few of them have Sally Port. So it's basically, it's kind of like an underground entrance, okay? Think about it, if you have a tall building or whatever with courtrooms. So when folks are being transported from the jail or even prison and they're going to court, some courts are built in such a way that they actually go through some underground secure part of the building, and then they're pretty much transported from inside the building to the courtroom that they have to go to without going through or walking through the hallways. Okay, so that's pretty much it. It's like a secured little prison, whatever, and then you would, that's how defendants would go to court. But a lot of courts that I've been into don't have a Sally Port. So, the sheriffs would just show up, and then sometimes folks actually come through the actual courtroom. Other times there's a separate entrance, but not every court has a Sally Port.
In the middle of the trial, we received another Sally Port interior back wall video. That was the video that is now sort of famously inverted.
Okay, so Benji likes I generally like courtrooms. I mean, some are, but you can tell this is it's a nice courthouse.
On October 10th, 2024, 2 days before Sergeant Jim Petro.
There Jerome goes. Jerome knows nothing about the case, but Jerome is like, corruption.
Tired, we received 4 videos. The Canton PD interior hallway, the Canton PD rear lot main side, the Canton PD rear lot cruiser side, and the Canton PD church side exterior Sally Port. And I highlight the word exterior because it becomes extremely important in just a moment. These are 4 videos, all of which show Brian Higgins in some way, shape, form, or fashion at the Canton Police Department on January 29th, 2022. Then on January 28th, 2025, the Canton Police Department main driveway side exterior Sally Port was given to us. That's a grainy and very wobbly video that nobody can sort of make heads or tails out of. You can see the general outline of a vehicle, but the condition or the quality is so bad that you can't tell what the condition of the taillight is, which is what we're interested in. And I bring this to the court's attention, or I highlight this, because this is the second exterior Sally Port video that we ever received. Okay. One on October 10th, one on January 28th, 2025. Then on Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Buchnick, dated February 28th, which is 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony. He goes on to say, quote, at this time, I reviewed the video and I reviewed video made available to me, which included video footage of the Canton PD exterior Sally Port. Exterior Sally Port. That means that the Massachusetts State Police not only had in their possession exterior Sally Port video, but they knew about it and were reviewing it during trial. But we didn't get any of it.
What's up, Jerome?
Until, as I just said, October 10th, we got one. January 28th of this year, we got the other. So that was withheld from us for the entirety of the first trial and all the way until at least October 10th, possibly as late as January 2025. And they've now admitted that. But who else knew about this withheld video in May of 2024 during trial? On cross-examination.
So can I just ask, was this of better quality than anything you had, or was it the same wobbly? Okay.
Same. Wobbly, grainy, can't make heads or tails out of hardly any of it. No. The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th, Trooper Buchnick admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony. Was that the video that they were reviewing together? Was it the exterior Sallyport video? We now know that Buchnick watched some sort of exterior Sallyport video. He admits it in this report that we just got 5 days ago. And we also know that he and Mr. Lally were reviewing video together before his testimony in May of 2024 because he admitted to that on cross.
So here is, what's up, Zeta?
Examination during trial, but I didn't have information about what he was reviewing because we didn't have the videos. So either they reviewed together the inverted video that was then played and knowingly presented false evidence to a jury and to this court, or they reviewed exterior Sallyport video and intentionally withheld it from us. This is binary. It can only happen one of two ways. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally. Either way, the withholding that evidence admitted to now by Trooper Buchnick was obviously egregious. It was obviously.
I'm sorry, folks. Us parenting. In any event, let's see. What is Jerome saying? Let's see. What is Jerome saying? So the defense is claiming Brady violations. Okay, to simplify it, a Brady violation. It's pretty much the defense claiming that the prosecutor did not disclose evidence that could help a defendant's case. Okay, I don't know why Brooklyn is saying that the state is claiming Brady. We did not get to the state yet, but that position would not make sense for the prosecution, because if the prosecution is claiming Brady, they are pretty much saying that they are in the wrong, and I just don't see the prosecution saying that. All right, let's play this.
Error. It was obviously calculated. Another important material fact not in dispute. On April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Sorry, can I just get back to that, what you were just discussing about May 2023?
Yes.
How is that exculpatory?
Because the videos themselves, as the court will see through the presentation of my oral argument, that the fact that those videos all just happened to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward, all tend to show that the Commonwealth doesn't want the condition of the taillight to be seen by anybody when it's pulled into the south.
Okay, I see what they
That
say.
is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
I will get to the prejudice.
Just answer
as
the
I go and
question.
move through my
Now or
argument.
no?
just-
If you can.
Yeah, that's the thing. I don't understand why Jackson is saying that. Why? Yeah, that was. Let's go back. Let's go back a little bit. Yeah, that's a weird. Weird is not the right word. I don't know why Jackson
When it's
responded.
pulled into the salad board. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
I will get to
Yeah,
the prejudice.
that part, I'm like, what do you mean you'll get to it? The judge is asking a question you have to answer on the spot. I mean, that's why I don't know that I could ever get to the Supreme Court. I have a friend that thought I actually had potential to get to the Supreme Court, but I'm talking about the U.S. Supreme Court, not, state Supreme Courts, because the way that it works in Supreme Court, you typically have justices just firing questions away at you like that, and you have to answer on the spot. So I do not understand why Jackson expects the judge to listen to the entirety of um, his argument before she can get a response. That I don't know.
Prejudice as I
Do it
move through my
now or
argument.
no? If you can, if you're going to do it later, that's fine.
I will do it later. I will do it later. I think the prejudice is cumulative. Obviously, we didn't have the information that we needed to be able to cross-examine the witnesses that we needed to be able to cross-examine at the time that it was
That's a
provided.
weird response,
Uh,
unless you
it-
don't
it
know
just-
the answer.
Very obviously. There were certain videos that were clear from some cameras on other days and other times.
All right, so listen, I'm gonna create some slides. So in my mind, I don't know that they'll come to fruition, but in my mind, I'll create some slides for you guys. Okay, but anyways, as far as exculpatory evidence, you're looking at primarily three areas. This is from the defense, I guess, for the prosecution as well, in order to avoid issues of misconduct. But from the defense perspective, they're pretty much looking at three types of areas. They're looking for evidence that can exonerate a defendant. They're looking at evidence that could reduce a possible sentence, and then also evidence that could challenge the credibility of a witness. So what Jackson is talking about here, he's basically saying that they did not have sufficient, or at least the prosecution should have turned over more material that would have allowed them the opportunity to properly cross-examine the witness. Okay, Olbag told me to parent. And then Jerome apparently is not impressed by his stack or the lack thereof, because there's not pretty much of a stack because it's kind of paper thin. Brooklyn said, so I don't think you'll pass the nomination for Supreme Court with this channel. No. I never want to serve. I never want to be a judge, first and foremost. Okay. Listen, people have gone on to do racist things. So this channel, I don't even know. I'll take that back. Even if I wanted to be on the Supreme Court, which I don't, there's a specific pathway to getting to the Supreme Court. To get to the Supreme Court, you pretty much have to be Ivy League, okay? You have to go to an Ivy League school. And apart from just going to Ivy League, you pretty much would have to work in DC. You'd have to clerk for a justice. That's how you work your way up. Like, you cannot go from, just because you're brilliant or whatever and think you're eventually going to end up on the Supreme Court. That's not how it works. That is not how it works. Brooklyn, we've had a racist. I'm pretty sure there have been more racist presidents in America. We have a Doge with a very problematic Elon. Even people that were recently, confirmed that are part of Trump's cabinet, they all have problems not even problem. A lot of them have serious character flaws. So this channel, me cussing on here a little bit, me cracking up here with Jerome a little bit, that's nothing. And I don't even think that any attorney of color or otherwise should be held to that standard, because the standard is pretty much non-existent, considering the unqualified folks that have gone on to, I suppose, get jobs that they are really not qualified for. So this statement of yours, I don't agree. Anyways, Jerome says appeal court seems more fun to me. I don't know. When I was in the public defender's office, I considered moving to the appellate division, but I don't know. I actually prefer being in court. I prefer trials from the onset, but with the exception of federal court. I think for federal court, you have to handle the case from inception all the way through appeal.
But these cameras that were late discovery that was provided to us just so happened to all go out. They all find their way to be defective in one way or another.
Oh, and here's what I was going to say. No. I wanted to argue cases before the Supreme Court because I wanted to do death penalty cases, but didn't get to do that. Probably won't.
On April 10th, 2024, the DA filed its certification of
We have 26 minutes, folks.
giving us all evidence that they had in their possession. And that
26
they had done a
minutes.
reasonable inquiry. Both of these, that certification was just flat not true. How could that be true? And we're still getting video evidence that is in their possession, custody, and control in October, in January. How could that
26
possibly
minutes.
be true? It isn't true. And it's illuminating when you look closely at the Commonwealth's opposition to our motion. First and notably, the Commonwealth makes these broad statements couched as fact. They're bold pronouncements, and there's myriad excuses in their opposition paperwork. And it's backed up by next to nothing. Not a single exhibit at the time they filed their opposition. There's some exhibits that have been lately provided, including some exhibits just a few minutes ago that they're now adding to their exhibit list and to their opposition. But at the point of fact, at the time they filed their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general, the only thing that they had attendant to their opposition was this joint affidavit that doesn't address any of the defense allegations at all. Contrast that with the defense motion, which was supported by nearly 20 fact exhibits. There may be a reason why they didn't support their positions with exhibits at the time. It's because the facts don't support the Commonwealth's position. These are indefensible.
That's all you
and
have,
indisputable
Jerome.
facts that I'm
26 minutes.
explaining to the court about the turning over of these Sallyport videos. Specifically turning to the Canton PD surveillance video. The opposition says, or reads, the Commonwealth provided the defense with a.
I just always like to read along. Where does it say it? What page you on?
I don't have the page number.
Okay.
It's the point at which the Commonwealth indicates that they provided 90 photographs.
Okay.
Crime scene photographs in support of the vehicle in the Sallyport. That is a distraction. What they don't mention in their moving papers is
I
that.
don't know. I prefer to hear both sides. I prefer to hear both sides before I, come to a conclusion. And the reason for that is because obviously I'm not an attorney for Karen Reed or even for the prosecution. So under these circumstances, we don't exactly know if they are, they're making two completely different arguments. But even under these circumstances, we just do not know what the other side's response is going to be. But I do not dispute, though, that the investigation in this case, based on the first trial, was very, very questionable.
The date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when the vehicle was brought into the Sallyport. The only thing we would have would be the videos, the surveillance videos, all of which are somehow, some way defective and which were held in their possession in some instances for nearly 3 years before it was turned over to us. So it's the condition of the car at the time that it was brought into the Sallyport on January 29th at around 5:30 p.m. that matters. That's the only time that it matters. The other evidence referenced by the Commonwealth about a 5 a.m. ring video and Canton police cruiser at 8 a.m. and the independent observations of Dighton police officer Sergeant Barrows, they all corroborate the defendant's contention that the taillight was cracked and not shattered at the time it was brought in to the Sallyport. And we're still talking about the condition of the taillight, obviously, when it was brought into the Sallyport. The Commonwealth.
Why do you want to speed it up? We could try, but I'm the type, you guys know that I go back so many times because I need to hear everything that they're saying. But if you want to speed it up, we can do that. I think this is normal, so we go here.
Next mentions that Lieutenant O'Hara from the CERT team arrives at 32.
I don't know. He's moving weird. He's moving a little weird. I don't like that. I do not like that. I'll let it play like this for the rest of the live, but I don't know. It's a little weird.
Fairview Road at 4:56 p.m. They then go on to mention that he was preceded by another trooper at 4:54 p.m. and that the car got to the Sallyport at 5:30.
All right.
suggesting obviously that the search began and
I know it sounds so weird. It's gonna take me a while to get used to this.
pieces were found before the car ever arrived. That would be interesting if it were true, but it's not true. It's a distortion of the truth. It doesn't matter when the CERT team actually arrived and drove up there and sat in their warm cars and waited for other team members. The last team member to arrive didn't arrive until 5:41, 11 minutes, long after the car had already been secured in the Sallyport, long after Trooper Michael Proctor had access to that passenger taillight. The first taillight piece was not seen or found or recovered until 5:45 p.m. after the vehicle's arrival at Canton PD. That was seen.
So weird.
We can see who's got access to the vehicle and who makes access to the vehicle in that inverted video. Once we turn it back around, it's very obvious. It's Michael Proctor milling about at the passenger taillight. These are important details to get right. The timing matters. The opposition claims that the defense theory is quote unquote evolving. They write that the defense, quote, struggles to establish how the condition of the defendant's broken taillight in Canton, in the Canton PD Sallyport, is in fact exculpatory. How is that exculpatory? The condition of the taillight, that it was cracked and not shattered as it moved into the Sallyport. How do we struggle to describe that as exculpatory? Of course it's exculpatory. Of course having those videos withheld from us is prejudicial. There is no struggle. It's on the video. It's on the ring video that establishes that the right rear Lexus hit the back of the Chevy Traverse, cracking its taillight. The Commonwealth, pretty desperate to ignore that inconvenient fact or that inconvenient piece of video evidence, literally previously said in open court that the Lexus only got close to the Traverse, only to be completely impeached when everybody in the courtroom at trial saw that 5,000-pound Traverse jostle, its rear wheel jostle, under the impact of the SUV right at the right rear or the passenger side taillight. Now the Commonwealth, with no factual support, no factual underpinnings whatsoever, says, okay, hang on a second. It did hit it, but it didn't crack the taillight. So whose theory is evolving? Ours or the Commonwealth's? The defense has never wavered. We knew that Michael Proctor, from the very beginning of this case, had been lying about the time he first took possession of that SUV. He claimed that it was at 5:30. The court will recall this. We had litigation concerning this. He wrote it in at least 9 reports that we were able to count. 9 reports or affidavits.
Okay.
Those affidavits sworn under oath. And the Commonwealth repeated that time for nearly 2 years.
Sorry.
Even going so far as to argue to this court that the defense got it wrong, that we were wrong because we failed to calculate for daylight savings time. So the Commonwealth battled us. And this is something I think the court has to really weigh in balance with the following conduct. The Commonwealth battled us for nearly 2 years on the singular issue of the
Benji,
time.
this is kind of too fast. Like it's like, I don't know, it's like speeding. Like speeding. Jerome wants me to do a test drive. Jerome's like, I like it. Oh, really? I don't know. It's a little, I don't know. I mean, I speak slow. I definitely speak slow.
That the SUV got to the Sallyport. They finally took their medicine at some point and had to admit to the false time and chalked it up to a Scrivener's error in 9 separate documents, memorialized 9 separate times, some of them under oath. And all the while they were battling us on the time that it got there. No, the defense is all wet. They're wrong.
That is too fast.
They just didn't account for daylight savings time. Oh, no, this was just a little mistake. It's not a big deal. It was a Scrivener's error. And the entire time they're making both of these claims, they had video in their possession that established unequivocally that that car was in Michael Proctor's possession at 5:30 and pulled into the Sallyport at 5:30. They knew the time. They knew.
So Proctor was the lead investigator, and that man is problematic. Really problematic. And here's the thing, because they had some type of group chat, I think, was it with other law enforcement officers, where they were talking about Karen Read. I guess they were talking about her appearance, right? And I mean, not to excuse his conduct or anything, but a lot of times, I mean, think about your job, okay? Your job. And overall, think about the times that you and your colleagues have said something about another individual, whether it's a coworker, whether it's a customer, a client, whatever. So that's what these folks did, okay? But the problem is they did it over text, and that's why I tell you guys, I do not text. I don't text people. And this just reminded me of an instance where, and typically I don't even talk about clients with people I work with because I don't trust people I work with. But that's just that's just overall. Excuse me, unless it's something really funny. Like, so in workers' compensation, there's something called work searches. Okay, more information than you guys need, but typically, I mean, the rules differ from state to state, but typically the rules or the process or the working is the same. So when somebody is injured at work, okay, sometimes folks are able to go back to work immediately, but that's not always the case. Or if they go back to work and then, their injuries just worsen over time and they have to be out of work. When that is the case, then they will be out of work for, I don't know, whatever amount of time. But in my state, I believe you first have to be out of work for about 3 days or so, for 3 days, and then you become eligible for indemnity benefits. Okay, that's just a fancy way of saying that the insurance carrier is paying them money to be out of work while they heal. Okay, because their injuries are at a place where they're not capable of working. It might be too much pain. They might be awaiting surgery and they're taken out of work, things along those lines. And when that's the case, they are entitled to, again, indemnity benefits. It's a certain amount, it's a calculation that's involved. In any event, so there's certain circumstances where, in order to be eligible for those benefits, in order for the insurance carrier to pay, they have to do work searches. Okay, but that's because they're released to full duty. Let's say maybe they got ran over by an excavator. The employer, their employee decides to fire them, which is kind of stupid. Like, not legal advice, but it's worse. Employers make it worse when they fire injured workers instead of just keeping them on the job and, I don't know, maybe fire them once the claim is settled. In any event, so they have to do work searches. What that means is that you pretty much have to apply for work. I have a client. So the client has been a construction worker most of his life, heavy exertional work. And so I told him to apply for work searches. I put it in writing and everything. But maybe I should have specified. Now that I'm talking about this, maybe I'm the one that did not tell him I probably did not advise him to the extent that I should have. But I told him everything. I told him you have to apply for jobs that are going to pay similar to what you used to earn. Steer clear of, working at a cash register because you're not going to make the same amount of money. And if you get that job, you get stuck. Tell me why this man applied to be a traveling nurse. Like, he doesn't even have a high school diploma. In any event, that's why I'm saying maybe I'm the one that messed up. Maybe I should have told him that apply for jobs that you actually qualify for. Okay, so that's something the paralegal and I were talking about today. It made me chuckle a little bit. Stuff like that I can talk to about other people, but instances where you're maligning clients, talking ill about people, putting stuff in writing, even if people do it, I do not participate. I just don't participate. I don't do it. And the reason, I mean, when Alan, I almost said Alan Jacobs. Who's Alan Jacobs? I don't know. Alan Jackson. When Alan Jackson was talking about, what is this? I don't know, something he was talking about. In any event, when I was talking about Proctor, right? When I was talking about the lead investigator in this case, Proctor, him and his co-officers maligning the defendant in this case, it kind of reminded me of an instance where there was a doctor that thought that they hung up the phone, but they were speaking ill of their patient. I don't know, problems. Anyways, let me play this because I'm just rambling now. We have 12 minutes.
That he had retrieved it at 4:12 in the afternoon and not gotten it to the Sally Port.
Oh, it's
until
definitely
5:30.
sped up.
So the Commonwealth was well aware in 2022 The Commonwealth and their agents were well aware in
Yeah,
2022
it's really fast.
that the SUV got to the Sally Port, and that was the centerpiece of the defense case. Their main
That's
motive was
funny.
directly impeach the lead investigator on this case, and they say that
Benji apparently zones out. I talk pretty
we struggle
little slow.
to explain the exculpatory nature of this evidence. It's not our struggle to explain it. It's their struggle to acknowledge it. Of course, that's
I
exculpatory.
don't remember how
It
slow he was.
directly and unequivocally impeaches their lead
That's just
investigator
crazy.
on one of the most important issues in the entire case. And that's only one aspect of the withheld videos that also is exculpatory. The other is the point
Yeah.
at which it would show the condition of the taillight. In other
Yeah,
words,
Proctor is problematic for the prosecution. I do not know how they were covered. I mean, I remember his testimony, and I mean, in his testimony, he was not, what is this? What's the term? He was not argumentative. He was not aggressive. I mean, he owned up for his mess, but I just do not know why he felt the need. And I mean, overall, people do talk about people. That's just how human beings are. That's how human beings are. But there's certain professions, okay, where I don't know that you put that stuff in writing. I don't know.
when it's being pulled in to the Sally Port, would it show the condition of the taillight before Trooper Proctor had access to it in the Sally Port? That's what we've been seeking.
No, you have to share,
The Commonwealth is well
Jerome.
known from the beginning of this case that the defense has demanded all physical evidence be preserved. This is not a game of Wordle. This is not something that's supposed to be parsed. All physical evidence be preserved. That's pretty straightforward. The Commonwealth shouldn't be in
I
the
know.
business of withholding exculpatory evidence
Jerome and
by playing some
Obag
sort of a gotcha
are
game with
communicating
definitions and
somehow.
words. They knew what we meant.
Poo bag.
We don't actually know what the Commonwealth has. So we have to be as broad as we possibly can when asking for evidence to be preserved.
Hold on, folks. I'm gonna turn this down. I'm gonna put it back to normal because that's just too fast. I forgot how to do it.
So
I
all
forgot
physical
how to
evidence
do it.
clearly includes the entirety of all the Sally Port
I forgot how
videos.
to do
The
it.
Commonwealth parses words by saying, well, we never asked for the Commonwealth to preserve the CPD footage from the Sally Port because the Canton PD is not the crime scene. You asked for crime scene footage, and Canton PD is not the crime scene. Well, first, I think that's a disingenuous argument that plays right into
Is
that sort of
it
gotcha that we
in their
discussed. I think
control?
the Commonwealth is better than that. That's not what we should be doing in a trial for murder. And second, let's not forget that District Attorney Morrissey actually defended publicly Michael Proctor by explaining that when he said, Michael Proctor said he responded to the crime scene, and of course we knew he didn't respond to 34 Fairview, D.A. Morrissey said, oh, he was talking about Canton PD, which is the crime scene. So they can't have it both ways. They write on page 4 of their opposition, quote, the trial prosecutor
What
was
the
not
hell?
aware of the existence of surveillance video in the Canton Police Department's Sally Port until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor, end quote. So they've taken the position, look, we personally did not know anything about that Sally Port video existing until we received the federal grand jury paperwork showing that Michael Proctor testified to it. First, the Commonwealth has to know that that is not the state of the law in Massachusetts. Massachusetts State Police and Canton Police Department are both arms of the prosecution actively involved in the investigation of this case. Not one, but two separate agencies not only knew of the existence of the footage, but the lead investigator actually admitted
Thanks,
to a
Brooklyn.
federal grand jury that he pulled the footage at the start of the case. He pulled it all.
I don't
And
know
he
how
said he-
large is the hourglass. I mean, we're almost done. We have 8 minutes, but this is too fast for me.
reviewed it all because that's what the case agent does. The Commonwealth cannot absolve themselves of the egregious and very obviously intentional discovery violations by Michael Proctor, by the Massachusetts State Police.
How large
by
is
Canton
the
Police Department,
hourglass,
By saying, I
Jerome?
personally didn't know about it. The cases are legion on that issue. Commonwealth versus Sleeper, 2002 case found at 435 Mass 581. And this is Hornbook law. Quote, a prosecutor's duty to disclose exculpatory information or exculpatory evidence extends to evidence in the possession of the police who participated in that investigation. And then Massachusetts Rule of Criminal Procedure 14A1A, the prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor. Persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in this case. Michael Proctor worked out of the Norfolk DA's office, physical plant.
Oh, I thought that was a riddle. We have 6 minutes.
There is
My
no
bad.
question that Michael Proctor
We have
and both agencies
6 minutes.
intentionally withheld that evidence.
Sheesh.
Let's talk about Michael Proctor's testimony before that grand jury. He was asked the following question. Are you aware whether there are any cameras in the garage or Sallyport where Karen Reed's SUV was parked? Answer, yes. Question, have you reviewed the footage of that garage? Answer, I saw one very grainy video and then another of Sergeant Buchnick and I arriving in the main entrance around 5:30 following the vehicle. Question, when did you watch the video from the Sallyport? Answer, I haven't reviewed it, sir, in quite some time.
So do you have those page numbers for me?
I can get them for you, Your Honor. I didn't cite them in my notes.
Yeah, if Ms. Little can get them for you before you finish, that would be helpful for my review.
I haven't reviewed it, sir, in quite some time, so I can't recall what's on there. Question, why did you review video of the Sallyport? Answer, we review every video we pull. We pull a lot of video. It's on the case officer to watch it. By his own admission, Your Honor, Michael Proctor recognized himself.
I don't know. Do you guys know? I mean, things are. Oh my goodness! It is 9:55, and it sounds like the paralegal is still at the office. That's crazy. In any event, I'm getting distracted. Do you guys? I know you guys are some tech savvy people. I'm trying to find a logo generator. Does anybody know where I can get that? Not AI. I mean, everything's AI. Any event, Jerome says, or should I say it's a recording on how much time you have? Then I'll know which glass to bring. We have 5 minutes, okay? We have 5 minutes. And then Benji, we'll be live tomorrow. We have to get through the rest of this hearing. I wanted to do it differently though. Let me think about this. I know I'm always thinking. I don't know who's drinking wine. Old Bag said this guy's cranking it out. Who? Jackson? I don't know. All right, let's get in here. Jerome, I hope you're not drinking.
Along with Sergeant Buchnick. That was likely the video that ended up being inverted by where Michael Proctor.
Jerome, come up here. 5 minutes though. We only have 5 minutes, Jerome. But I want to talk. I just want to clown a little bit. This stuff is too serious. We have 5 minutes. And I don't know, Benji's much younger. Maybe he knows where. I'm trying to find a logo maker. I could use Canva, but I don't know. I'll play this while I'm waiting for Jerome to come up here.
It was by the passenger side taillight.
All right.
And that was before any taillight material was ever recovered at 34 Fairview. That is highly inculpatory of Michael Proctor. It is highly exculpatory of Karen Reed. Another point of fact. By his statement, Michael Proctor admitted that, quote, we pulled, end quote, the video. That video is on a 30-day overwrite.
Marijuana.
The Michael Proctor testimony in front of the federal grand jury is at page 79, lines 1 through 13.
Thank you. Thank you, Ms. Little.
Exhibit C, is it Charlie?
Okay.
Who's Little? I don't remember her from first trial.
The video is on a 30-day overwrite, Your Honor. We all now know that.
Where's
We didn't know
Brennan,
that before
though?
just a few weeks ago. I don't expect that the Commonwealth knew that either. This is new to everybody, right?
Wait, he's
But-
still talking?
You have to have pulled the video within the first 30 days to even be able to review it. We've been getting these videos.
I'm quickly going to jump to
for not
Brennan.
months, but for years.
I'm quickly going to
Brennan, I have
jump
a
to
question
Brennan
for you.
because
As I started with a question for the defense, so I'd like you to explain to the court, please, what efforts the Commonwealth made to comply with the Rule 14 obligation regarding the Sallyport videos, and why the dribs and drabs of the way the discovery came in.
It may be most helpful if I give the court history.
I'm sorry. This man cracks me up. Hold on. This I need to listen to in normal tone. I don't know if he's reading a script, but this man cracks
Discovery
me up.
came in.
It may be most helpful if I give the court history as I've learned it about the production of video in this case,
Okay.
and it will explain in context the production of video and will help create the foundation so the court can understand and perhaps the defense can best understand.
All right. And just like I did with Mr. Jackson, if I need to, I'm going to interrupt you
Of course.
to clarify some of this. So know that that's what I'm focused on.
I
Okay.
understand clearly. In November
Fever in
of
here?
2024, the defense asked me to
Oh,
see if
never
I
mind.
could
You're telling me to
provide a chain of custody regarding the
you're telling
production
me to basically hire somebody on Fever. Got it.
of video in this case.
I'll take
And
that.
so I agreed that I would do that and
Thank
made best
you,
efforts to
thank
talk
you.
to as many witnesses as I could, review the
Let's
discovery,
see.
and speak to the attorneys.
What windows?
Now, when I started
What
sometime
windows?
in late September, I
Fever.
had found the
Uh,
letter from Chief Rafferty with the production of video in August. The letter or note was dated in August.
Ozark.
So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the Sallyport area. There was nothing about it that was particularly relevant to them. The defense theory did not make it clear to
Let me
them
see,
that
does
that
the
was
judge
important. There was no
interject?
motion filed by the defense.
At what point in time?
This is leading up to trial. At
Okay.
that point, there had been no request by the defense for video of the Sallyport area.
Sheesh.
What I learned is that
And that, I don't know. I need to watch. Okay, so this is 3:54. Tomorrow, I think tomorrow. Oh, Benji said those aren't windows behind the judge. I was not looking. I think I should be able to. Yeah, this is 4 hours. Tomorrow, I should be able to either watch this while I'm at work and just give a recap, or tomorrow might actually be one of those days where we start early. Let me see what it is that I have to do tomorrow. Okay. Okay, I believe Benji actually asked when is the next stream. So let me make up my mind. Okay, it's tomorrow. What time are we starting tomorrow? Give me a second. Let me think about it. Give me 2 minutes. 2 minutes to think about it.
Trooper Proctor had requested Sallyport video from the Canton Police Department.
I'll take a look now.
And the person who was the
Oh, back then.
custodian
Okay. I dream of
of
windows
Canton
too.
Police video who would download it from the DVR was Sergeant D.G.M. Petro. He made a request shortly after this event on January 29th,
Tomorrow.
2022. Sergeant D.G.M. Petro.
All right, tomorrow, same time, 8:30 p.m. Because I have to think, but Zeta has practice tomorrow, so I cannot start early. So tomorrow it's gonna be 8:30 p.m. And in all honesty, what I'm gonna do tomorrow is I'm gonna try and listen to this while I'm working, and then I'm going to take notes, and then I'll come up here and report back to my co-counsels.
Downloaded video from the front
Oh,
wall
those are
camera,
windows.
which was later characterized as
Yeah,
the blurry
definitely
camera.
windows.
And he left it at the
I know Benji has a thing for architecture, it sounds like.
front desk. Trooper Buchanan, at the direction of Trooper Proctor, picked up the video.
Proctor should not direct anybody to do anything, nothing at all. He should not even lead a dog.
And he brought it to Trooper Proctor. Trooper Buchanan did not look at the video at that time. It was given to Trooper Proctor. Trooper Proctor did not
Is this
provide
still?
it to the prosecutors. So
Hold on, let's quickly get in here.
let's start first with the claim that
I like this guy. I mean, I've not listened to the entirety of his response, but in this trial, I definitely like Brandon and I like Alessi. To me, they are a standout. I mean, they could go to trial and just mess up. But so far, so good. So far as the hearings are concerned, I've liked the work that they've both put on.
the Sallyport videos were tampered with. Canton went back before January 29, 2022, and they
Yeah.
took samples.
This
of the
is the prosecution. Jerome, I'm going to do you justice, okay? When I get to work tomorrow, I just need to take my my headphones, okay? But when I go to work tomorrow, I'm going to listen to this thing from top to bottom, and I'll come back with a report. And if I have sufficient time, I'm going to listen to the one from the day before. I don't know, but if they are live tomorrow, we'll see. Anyways, I'll be live tomorrow 8:30 p.m. Eastern time. I'm going to call it a night here, you guys. And I think, honestly, as I think of as I think of just the format, I think when we don't have trials, we're just gonna come up here and talk nonsense. Okay, so Benji likes to admire. Okay, so you like to admire architecture. You might be good at it. You just don't know. You don't know. Yeah, but I'll be live tomorrow 8:30 p.m. Honestly, I just need to get through. I need to get through the first. Let me look at my calendar. Today was so stressful. Today was stressful. In any event. Okay, so tomorrow's Thursday, and then we have Friday. I do have some deadlines. I have a hearing on Monday, so 2 hearings. Let me look. I have to make changes to the format. We'll do something. We'll do something. Benji tried it on Minecraft. And how far did you get, Benji? Okay, so we'll do 8:30 p.m. tomorrow. So this is gonna give me a chance to listen to this thing in its entirety tomorrow. And then I'll come up here and report back to my folks. So Brooklyn said next hearing is March 18. Okay. That's gonna give us sufficient time to actually. When is March 18? I'm sorry, that sounded actually farther than it is. Okay, it's about 2 weeks. Okay, that's not too far. That's not too far. That is crazy. I mean, I guess it's a good thing that they're having these they're cranking out these hearings now, but it's pretty close to it's really cutting it close to the actual trial. Okay, other building type games. You should try. Hold on, let me find that game. I've not played that game in a while. I was thinking about it. I don't even know what it's called. Hold on. There's a game called Design Home. I've not played it in a while. Maybe you can find some inspiration on there, Benji. Design Home. I think that's what it's called. Okay. Yeah. So shout out to Brooklyn, okay? Shout out to Brooklyn. You need to get on Design Home, Benji. Get on Design Home. You can design some homes. Right now, I literally just clicked back in here. And they gave me 5,000 diamonds, 10,000 cash, and 75 keys. It's been a while since I've been here. Apparently, it's inspired by AGTV. Okay, maybe I can give you guys my user or whatever. I think I have a user, maybe not. I don't know why they're selling. In any event, let me go, you guys. You guys know I can do a whole lot of talking. I need to go talk to my man, okay? All right, I will be back tomorrow, which is what, Thursday? 8:30 p.m. Eastern Time. Shout out to Old Bag Benji, Brooklyn, Cali, Fever. I think hopefully I mentioned everybody that's actually here. Yeah, but shout out to Old Bag though. A big shout out to Sarah. Okay, folks, I really need to go. I don't stop talking. I need to go. Have a fantastic Thursday. I'll see you guys tomorrow.